I should let you all know that I read the proposal that was put together to get the grant to do this. And it's gratifying to see so many people in the room for this talk, because it's clear that heart and soul went into putting together the proposal. And the spirit of opening up these questions to the Cornell community was very, very clear throughout. As anthropologists, the three of us tend to work more solitarily than some other scientists. I've always been impressed with my colleagues in rural economy and sociology who can put together the big project. So any of you who are looking to do your next grant and have to figure out how to collaborate, take a look at that project and the cooperation in terms of just writing that proposal, because it's really a beautiful piece of work that asks the questions that make you say, oh, I want to, it's not like, oh, I want to evaluate that proposal and give it an A. It's, I want to be in that project. And that's a really exciting thing to see. So I just want to point out that that's there. Also want to thank Paul for inviting me, and thank Alita for her generous exchange of materials, which has been so far a one-way, unreciprocated exchange. So she hasn't seen what I've written yet, but we've had conversations, so she's been able to think a bit about what that would be. So, what is land? Is this land? This is what is in the backyard in Alberta, where I come from. Down here they call it the tar sands. Up there they call it the oil sands, and it's seen as a place of prosperity. Because the entire top surface here has been stripped entirely away, I wondered if this was seen as land, or if this is actually the quintessential not land, the thing that's been so entirely transformed into something else that we can no longer think of it as land. So that's my perspective in Alberta. That's my question in Alberta. But what I'm here to do today is to tell you about other people's conceptions of land. So, what is land? In anthropology, our work is all about finding the right question, the one that hits what ethnoscientist Michael Agar calls a cultural rich point. It is that place where a gap in understanding between interlocutors is recognized, and the inquirer is in a position to hear, where we might be rewarded by a wellspring of explanation from those we engage with as anthropologists, those that we engage with who can see that we can finally distinguish figure from ground, can finally listen and see what might be fundamental in their world. And such was a question posed by Paul when he sent on a deceptively simple email question: what is land? When that email arrived, I was on a brief visit to Aotearoa, New Zealand, staying with Maori hosts, Tanata Whenua, people of the land, living on their ancestral lands. And these people include lawyers and intellectuals, one of whom is a fellow linguistic anthropologist, Patu Hohepa, who did training actually in the US with Noam Chomsky, and worked both at Bloomington and at MIT before returning home. Patu Hohepa and three other named claimants are in the midst of a struggle to regain control of lands via hearings before the Waitangi Tribunal. I'll tell you a little bit about the case in a moment. But just for now, know that we are sitting at dinner. I'd mentioned an email came in, and so I told them about the question Paul had posed. And the wellspring, or waipuna, opened. Whenua in Te Reo Maori may be glossed as land, but the notion of the word it equates with tends to be limited by that, land whenua, where some will infer the same boundaries on conceptions of land and simply substitute whenua. There is a reason why Maori use the word whenua and not mere land when they're speaking in English for the meanings attached. Turning our question to the fundamental, what is land, animates what I had actually thought was quite familiar. Patu didn't go to the conventional when he was talking about land. He turned to something else. He turned to the notion of flats and folds where some of the children live, a place that is special for cultivation. Now, if we turn back just a wee bit here, you'll see a land that's been flattened, folded, and transformed, much by human influence. But Patu lives in a land that has been flattened, folded, transformed by volcanic action and other actions. And in past times, by the separation of Papatuanuku, Papa, or Mother, the Earth, and Ranginui, Sky Father, the two who were so in love and so inseparable that their poor children struggled in between them to get these two to separate just a bit so humans and others would have a chance to be in a new world in daylight. And that pushing apart, that transformation, told me something in a moment about land being more than what I thought of as, perhaps because I've spent so long in Canada, the top 6 inches, the topsoil that can be seen as property in Canada. Now, the flats and folds was just the beginning. And that was the beginning of an understanding of a larger sense of land. Because Patu then was asked by me a simple question. And I've got to tell you, I don't ask questions as an anthropologist. I listen, and he's always saying, because he's a linguistic anthropologist, but Maori and wanting to share his culture with me, just ask anything, Andie, just ask. And I never do. I know that there are people like Charles Briggs who wrote a book when he was a young anthropologist, Learning How to Ask. And that's a lovely, lovely question. But to me, it was always about learning how to listen, how not to ask the question that constrains what a person is going to give you as an answer. But because of Paul's question, I felt compelled to ask the next thing. Is moana, is why, is the seawater, is water in general, is water part of land? And this is where Patu continued. Patu said that the starry sky was part of the water world. And so here was another piece that I hadn't understood at all. And I should tell you, these kinds of discoveries are probably pretty naive. I haven't been working that many years in Aotearoa. So, Alita, the things that you know about all of these places, that kind of connection, is probably something many Polynesianists are quite aware of. But I was also bringing my background in Salish studies to this as well. And so that set of preconceptions, layered on top of the other ones, meant that I hadn't thought about these things at all yet. So I asked if water was part of land and got a strange answer. Patu said that the starry sky was part of the water world. He went in to speak about 12 heavens arced over each other, and the spiraling Tawhiti Ma'atea, the universe. And he talked about Tane, the creator of people, God of living things, and Tane Mahuta, guardian of the forest, Tane, parent of the dawn maiden. Now, how does all that fit together? Well, the arcing out between Papatuanuku and Rangi has something to do with the brother of Tane, Tu. Tu, the guardian of people. He was the guardian because he had to develop people into warlike beings. The Milky Way is a brother too. When he pushed the spheres apart, his back became the arch to hold the father, Rangi, away from Papatuanuku, the earth mother. So 12 arched heavens, the spiraling of the sky, the spiraling of Tawhiti Ma'atea, the universe. And then another figure swam into this picture, Pia I Arangi, the long white shark of the sky, the great fish of the sky, also known as Ika Anui. He promised he'd give Tani all the information on climate and changes of weather conditions if he would narrow his body down. And they speak of a lean and hungry time that came at that point. Pia'i Arangi also said that he would talk about how the jet stream works. And if you are of sufficient rank, you can learn about those things. And if you are of sufficient rank, you can become an eye looking down when you pass beyond the veil. And Patu said that all the stars are eyes looking down. Now, I've been going to Waitangi Tribunal hearings, hearing ideas about land framed in ways that I thought were Maori ways of seeing things. I went to these tribunal hearings to hear people talk about their land in their own language to tribunal members who also speak Maori and grew up as Maori. But these stories, although they were indicated by the speakers in the room who all knew them, weren't explicated for me, the outsider. And so there was a lot that was really going right by me as I was looking at some of the legal complexities that I'll turn to later. Patu then turned to the testimony of Whangaroa Ngatikahu from the hearings that we had heard the day before. He talked about one of the women, Ruhia Collier, who spoke about a particular bird, a bird for which they are the kaitiaki, or caretaker, a bird which, because of the actions of the Crown in taking their land, the flight path of that bird had been disturbed. Remember that mention of the jet stream? Well, these flight paths, these trajectories of flight for birds, this too is seen as part of whenua. It's seen as part of land. So when you step into a legal framework, one that's dominated by the Crown, where there's not a lot of law yet around certain places that are seen as not land. For example, jet stream, airspace, viewshed. All of a sudden, there's an opportunity for Maori to cram through and make a little bit of light as they're pressed on both sides by Crown and ground. So here we find a place where we can attend to a very well-developed Maori tikanga, or customary law, in terms of making arguments about what Maori people should be entitled to in the world that was wrested from them by a mistranslation of a treaty in 1840. Beyond that, he looked again to the controlling of winds, of routes and voyaging. He looked to then the implication of the voyagers for owning all the way to Hawaii, because they understand the paths guided by the stars that are their ancestors and by the waves, the taniwha, the guardians underneath the sea that cause those swellings. He talked about all those places, all those beings as part of land. So to Ao Maori, the whole world is all whenua. Now, how to miss that? It turns out that most people these days in Aotearoa, New Zealand, have read a book by Hiranimoko Mead. His famous daughter is Linda Tuiwai Smith, but he too is an anthropologist, and he wrote a lovely little book about tikanga Maori, ways of explaining it to a wider audience. And here's what he said. One of the aspects of our tikanga Maori is concerned with placenta. Its common name is whenua. Whenua is the medium between mother and child, succoring new life. After birth, the whenua as land succors the whānau, that's the family. The two whenua are similar, both are real. Whenua as placenta allows a fetus to become a baby, a small human being with the potential to become a strong and healthy adult. Whenua as land sees the person develop and grow, make their contribution to society. And this is something that this primary place, this fundamental connection between whenua, placenta, and whenua land is most readily apparent in the concrete action of new Maori mothers who, in accordance with Maori tikanga, send the whenua to be buried in a special place in their homelands so that their children are bound to it. A tree can be planted, in my experience, or some other marker provided when the whenua is buried. And this general practice is very well known in Aotearoa, New Zealand. And it turns out that well, if you just talk to any man on the street, they're going to know that association of whenua land and whenua placenta. But it's that practice, that thing, placenta, that's seen in a very different way in a Western medical context, and the burial of it in the ground, that doesn't necessarily make sense to the people who are telling you about, oh, that word whenua. That's all the same thing. So I want to return now to Hiranimoko Mead's description of it and tell you the bit that I'd always overlooked. It's in the last line of his little description. So it's a simple paragraph. He ends it, whenua as land sees the person develop and grow, make their contribution to society, and then be born into the spirit world. So when people talk about whenua as land and whenua as placenta, they're talking in a very real way about the land actually, the earth part of land, the water part of land, being that thing that nurtures us before we detach and go to that next place. And whenua, placenta, is buried. It's tapu. It's treated extremely carefully and reverentially. And it's seen as part of the child, according to Mead. It doesn't have the child's personality, but it is a part of the child. So that earth, that is a part of Te Ao Maori's ideas about what humans leave behind, a part of themselves. That is the placenta. And they go on to the starry sky, if they're fortunate. Their eyes then look back down upon the world. So, I want to think about some practical ways to think about this with respect to the research group. Land and not land. I think that the not land tends to be one of the places where you're going to see some land grabs. In terms of land, and so the way we consider it land in opposition to, rather than as part of a greater traverse, which would now, I hope for all of us in the room, include ideas like foreshore, seabed, and airspace. I think we would have the opportunity to demonstrate it is precisely how land is conceptually framed, as arable, as traversable, as possessable, as readily subject to the systems of tenure or not, according to New Zealand's common law-based legal system that permits the continued exclusion of certain Indigenous land claims from consideration by the court. I want to draw our attention then to the less obvious forms that dispossession can take by a limitation of movement and access to resources and spaces deemed not land, but nonetheless desirable by settler populations. The New Zealand government's practice of excluding shorelands from claims or deeming them to be commons can in fact restrict or deny how and where Maori can travel on the land. Access to resources found there and to local social relations they foster, gathering and sharing of shore foods, caretaking of the land, sharing of knowledge of the land, on the land with others in their circles. And for those of you who read, and thank you for doing it, really, it's always nice when someone reads your work, you know. For those of you who did read chapter 2 and 3, even if a gun was held to your head because it was an assigned reading, you'll know that these ideas of the land being a full-size map of experience where these stories are anchored to places. This is true for Maori as well. At any rate, not being able to access those areas and claim the caretakership, the kaitakiangatanga that they should. The people are thereby wrested from, the land is thereby wrested from their grasp, along with what it can teach. I argue that deeming such spaces as other than land or not land introduces an opportunity for settler societies to exploit a gap in the law as well. The privileging of a particular meaning of land, including with respect to agricultural land, has also allowed oil and mineral extraction companies to find legal loopholes that could allow resource development without acknowledgement of prior claims. The lack of emphasis in the courts on shorelands as land might still afford Maori as Indigenous peoples, though, a toehold, if not yet a secure legal footing, in land claims negotiations to be pressed with respect to rights to shorelands, seafloor, and airspace. These are less well developed, but in relation to other aspects of land grabs before the Waitangi Tribunal, these could fill a vacuum in law. Now, I'm just going to, because I have 2 more minutes, I think. I want to turn to just a couple of slides here. This is Titi Marae. This is the place where the original Waitangi Tribunal was signed, and I have to tell you just a bit about the case, just to frame this. In a case currently before the Waitangi Tribunal, which is a quasi-judicial body in Aotearoa, New Zealand, there are 2 key documents, a treaty and a declaration, that are being now re-examined so that the fair interpretation of their meaning can be brought to bear on legislation in New Zealand. The case is considered profoundly important to the way the formal constitution will be created for the country. There are documents that may be seen as setting out a relationship between founding peoples of the islands and the British Crown. These are He Whakaputenga o Te Raratiratanga o Nutirini 1835, hereafter He Whakaputenga, an instrument declaring Maori sovereignty, and a second document, Te Treaty o Waitangi, hereafter Te Treaty, an original signed treaty of 1840, written only in Te Reo Maori, the language of the Maori. The Treaty of Waitangi is the name given to the problematic English translation of the treaty. Members of Ngāpuhi Iwi and their land, oh sorry, I didn't realize I had this. So here you see, I have a completely blank screen, which is really strange. I don't know why it does that, but I'm just keeping my finger on the button. He Whakaputenga and Te Treaty o Waitangi, extremely important, but I won't go into the reasons, further reasons now, but the area in blue is the area that is currently being considered by the tribunal. The land takings by the government from 1840 on have been immense. This is a tremendous struggle. A week of hearings has just concluded, a week of hearings in which Ruhia Collier made the comments about the flight of the bird no longer being something that could be counted on, thanks to the taking of particular lands where those birds nested. This is the phrase I finally come to, mana tuku iho, an inherited right or authority derived in accordance with tikanga, or Maori custom. What the government promised to Maori people at the overturning of a major case by legislation, the Ngāti Apa case, the government decided that what was said in that case couldn't. I'm sorry, because I can't see my screen, I can't find. There we go. Okay, so in the Ngāti Apa decision, Maori had potential access to the foreshore. Here's the beautiful words of Dame Sean Elias, the judge in the case. The common law, as received in New Zealand, was modified by recognized Maori customary property interests. If any such custom is shown to give interests in foreshore and seabed, there is no room for a contrary presumption derived from English common law. The common law of New Zealand is different. This is a very powerful phrase. She's moving from precedents only set in British law and then in New Zealand law to something that fully accommodates Maori law. there's something else she's done that's quite magnificent here. She doesn't tell you what that law looks like. She can't really find out all about that, except by the kinds of experiences that we all have discovering these things about what is whenua over the course of a lifetime. So what she's written is something exquisitely open to further understandings of what land is. Now, unfortunately, this was overturned in a piece of legislation, the Foreshore and Seabed Act, followed by one that is even worse, the Tekutai Moana Act of 2011. This worse act has declared that the foreshore lands, let's hope, Foreshore and Seabed Act, I'm just going to pop along. The foreshore and seabed, they've decided, is not land that can be owned. The Crown has decided that a new kind of land will be in New Zealand, common marine and coastal area. Crown ownership of the foreshore and seabed is removed and replaced with that which is not owned and cannot be owned by any person. What I argue, and I hope this is one reason I'm really glad you have the cameras on, because New Zealand really has to listen to this. It's a very serious problem. You know the work in Australia, you know about the problems of terra nullius in that country. One of the things that people from Aotearoa, New Zealand, have always been very proud of is that they had acknowledged at some point a relationship with Maori as owners, as tanata whenua of the land. What they've done with this new legislation is actually to introduce a new form of terra nullius into New Zealand law by legislation. So the creation of a brand new kind of title gives rise to this form of terra nullius, in the original sense, land belonging to no one. And you can see, I think, how this is completely at odds with Maori tikanga. So I'm going to leave it on that note, and thanks for your indulgence, because Paul never did zap me with these things. And I'll say thanks very much. Thanks.